So, as I said, it's my distinct pleasure to introduce Professor Zimering. He is the William G. Simon Professor of Law and Chair of the Criminal Justice Research Program at the University of California, Berkeley. Since 2005, he has been the first Wolfen Distinguished Scholar at Boalt Hall School of Law. Professor Zimering has specialized for 4 decades in the empirical study of legal institutions and the assessment of the behavioral impacts of legal regulation. Educated at Wayne State University and the University of Chicago, he joined the Chicago faculty in 1967, immediately after graduation. He was director of the Center for Studies in Criminal Justice at the University of Chicago and of the Earl Warren Legal Institute at the University of California. His recent books include, and I believe you said 25 books now last night. His recent books include The Contradictions of American Capital Punishment, An American Travesty, Legal Responses to Adolescent Sexual Offending, American Juvenile Justice, and The Great American Crime Decline. The Next Frontier, co-authored with David T. Johnson, is to be published in late 2008. In addition to his scholarly writing, Professor Zimering is a frequent author of opinion, editorial, and general essays. Pieces of this work are reprinted as models in 8 college writing textbooks. So it's my pleasure to welcome and introduce you to Professor Zimering.
And it's a pleasure to be here. There are, it must be said, 2 things which are very special about the combination of this invitation and the topic of my lecture. One of them has to do with the name of the program that brings me, and the other has to do with the location that we're sharing for this morning. Let's start with the Beto chair. And let me tell you something you already know. Criminologists don't run the world. Okay, but having said that, and if you spend 2 days in Texas, you learn that early, there is a balancing point, and that is that some criminologists can make a difference in the world. And that is the special resonance, at least to me, coming in from afar, of the Beto program and of George Beto as a model. Good people can make a difference in a field where the supply of good people is not equal to the demand on them. And I think that honoring the Beto tradition and commitment is something very important to do. So I'm pleased to get the invitation. And also a little bit daunted because they didn't ask me here to give a speech on juvenile justice. They didn't ask me here to give a speech on the Great American Crime Decline. The invitation was for an analysis of American capital punishment in Huntsville, Texas. Now, that's a little bit, from my perspective, like being asked, and it's a great honor, to give a lecture on chocolate in Hershey, Pennsylvania. This is the center of execution activity in North America, not in the world. Up until very recently, Singapore, with about 1/7 of Texas's population, conducted more executions than even Huntsville. But certainly within the developed Western world, the defining reputational aspect of the community that I'm visiting is the practice which is the subject of the lecture. That said, this is also a lecture in a program of criminology where intellectual rigor and empirical information are very high values. in an area with this emotive significance, is there enough sort of ideational content in what's going on in capital punishment in 2008 to be a good George Beto lecture? Yeah, I think there is. I think that this is an odd and very interesting time in the history of capital punishment in the world, in the United States, and even in Texas. But I want to begin by giving a really long-term historical context. Killing as a punishment for crime has a history which is every bit as old and maybe even older than criminal law. But state execution has been a target for reformers, particularly in the West, for well over 2 centuries. And during that period of time, usually the boundary that people think of is the publication of on criminal punishments in 1769. During the period of time where there has been any real questioning of the of death as a criminal punishment, death went from being a common penalty, the sort of thing that happened as a standard outcome in criminal justice systems, to becoming a rare punishment for very serious crimes through the 19th century. And while that was going on, what happened instead was the rise of the prison as a dominant institution for the punishment of serious crime. After the Second World War, so maybe we can get away from ancient history, nations began to not only disuse capital punishment, but to abolish it in a very substantial pattern. By about 1981, Western Europe was what we would call an execution-free zone. The last country in Western Europe to abolish capital punishment was France. The method of execution, incidentally, right till the end, was the guillotine. And the date in which abolition took place was 1981. Well, let's go to about 1980, and let's talk about what's been going on in the last quarter century, which just incidentally is also the period that I've been studying this as an academic. If we take 1980 as the start, about 37 countries had abolished capital punishment in the 2 centuries after On Crime and Punishment had been published. That's a lot of countries, and it was also a concentration of a lot of developed countries, but it was only 22% of the state entities that existed in the world as of 1980. But business picked up rather quickly after that. What we have, except for the last 2 years in this particular slide, is every 5 years a snapshot of what has happened to the legal status of capital punishment. And we go from 37 to 46 to 60 to 71 to 89 to 100 nations, more than half the world, that have formally abolished capital punishment either for what they call ordinary crimes or for all crimes. All of a sudden, we have gone over half the countries in the world with former abolition. If you add to that countries that have the death penalty on the books but haven't used it in a decade, We're talking now about 2/3 of the nations in the world. So policies have changed very substantially, and they have changed relatively recently and also very fast. By 1980, you had 37 nations. In the next 25 years, you had almost twice that many nations adding to that. Now, what's been going on in the United States? Well, we're going to shift from legal status descriptions here to sort of a picture of what has gone on in the long term with executions in the United States. As is the case, certainly after World War II all over the world, the long-term trend in the United States from 1930 to the middle of the 1960s was downward. The peak rate of executions, the peak number of executions in the United States was 199 nationwide in 1933. By 1967, executions had dropped to near zero, and then entered a period of 10 years without executions when federal courts essentially put the practice on hold for a series of legal challenges in which the United States Supreme Court tiptoed up to the edge of declaring capital punishment unconstitutional. That case was Furman versus Georgia in 1972, and then backed off from that with a series of cases decided in 1967, ordinarily organized under the heading Gregg versus Georgia. So then what happens is that from 1977 to 1998, executions go up very substantially in the United States. It looks for a bit like executions right by 1998 have gone up to where they were in about 1955, just sort of a return to the level that we had in this country. And if what you're dealing with is national aggregates, that is statistically correct. But in 7 or 8 minutes, we're going to get to some materials on the regional distribution of executions that suggest that that is a statistical illusion or an aggregation error. That while the number of American executions is about what it was in the mid-1950s at its peak in the late 1990s, the distribution of executions was vastly different. Now let's look at what's happening here. That high was 98 executions nationwide in 1998. 37 of them were in Huntsville. Texas, because of its population and legal and cultural structure, has been by far the leading executing state in the country, but not far removed from a deep southern pattern, which also includes Oklahoma, Virginia, and did for a while include Florida as very high executing environments. But let's go back to the national aggregates for a moment. You've got 98 executions in 1998, and then you have a very substantial drop that starts right at the turn of the 21st century. And you have more than a 50% decline in nationwide executions over the period from 1998 to 2007. Now, how much of that is a glitch because of the legal challenges to lethal injection? Through 2007, the answer is practically none. the 42 executions maybe in 2007, without that legal challenge, might have been 43 or 44 or 45. But the natural pattern has been one of substantial decline in the United States, even though the legal environment supporting capital punishment hasn't changed in any way that would predict that. And that is an interesting puzzle. If you're looking for an indicator of community values and legal system values, there is a better measure of changing attitudes toward capital punishment than executions, and that is trends in death sentences. But we only have that for the extreme short run, that is to say, for the last generation. And that is to say that at the beginning of this time series here in slide 3, we have tremendous changes in capital punishment statutes because the Supreme Court of the United States had ruled in the Furman case that solely discretionary jury choice between the death penalty and protracted imprisonment was itself a violation of the Eighth Amendment. So you had states changing the capital punishment statutes, and it took a while to get adjusted, but by about the early 1980s, the rate of new death sentences in the United States was above 250 a year. Now, let me make a point about regional patterns in death sentences. Death sentences in the United States are not as concentrated in the South as executions. That's interesting, too. We'll be talking about the state you live in and the state I live in, Texas and California, in a few minutes, comparing policy profiles. But if you're taking the temperature of legal and citizen sentiments toward the death penalty, trends in death sentences are a more direct way of seeing what citizens and district attorneys are thinking and feeling and doing. Because state activity and judicial restraint are too large a part of what determines execution patterns. And here, what you see is that the high point in American death sentence propensity doesn't occur in 1998, but occurs a few years earlier in 1994, which was, in terms of crime policy, probably the most fearful and nasty year in American political history. At its peak, death sentences in the United States were running about 300 a year. And then, just about at the turn of the 21st century, you have a sudden and precipitous decline that bears an amazing resemblance to the last 2 weeks of the Dow Jones Industrial Average. Whammo! Now, this isn't because of any challenges to lethal injection. This isn't a notion of execution and state activity. These are the death sentence procedures that district attorneys bring, the capital trials, and the jury sentences of death. And they have gone down in the United States by a little bit over over 60% in a decade. What's going on? Question mark. But the point to make about this, and also about the execution statistics that I gave you before, is that it is very important to put what's going on now in a very long-term context to try and explain it. Now, the thing that I can tell you about the pattern of execution by region in the United States is that it is absolutely astonishing. When Europeans, for instance, criticize American capital punishment policy, they don't know what they're talking about. And one of the reasons is because there is no American capital punishment policy. We have 51 different criminal justice systems in the United States, the federal and 50 states, and boy, do they differ. Okay, this slide compares two periods that had roughly the same rate and volume of nationwide executions. The period from 1950 to 1964, and the period from 1980 to 1999. And the first thing to notice in terms of the regional distribution of executions is that Southern dominance is not something that was invented relatively recently. A majority of all the executions in the United States at mid-century took place in the South, more than a majority, 60%. And for instance, the ratio there of executions in the South to executions in the then more populous Northeast during the period 1950 to 1964 was 4-to-1. So the point you would want to make if you're looking at that as a foreign visitor is, my heavens, the distribution of executions is very different by region. Look at it, for heaven's sakes. You have two large populous regions, and there's a 4-to-1 difference in their execution levels. To which the statistical answer, given what's been happening lately in the United States, is you ain't seen nothing yet. Let's take a look at executions between 1980 and 1999. The South does not now have, in its recent history, 60% of all American executions. It now conducted more than 4 out of 5 of all U.S. executions. Now, what that means is that the South at that point had 53% of the death sentences that we've been talking about. But with slightly over half of the death sentences, they're 4 out of 5 of the executions that happen, so that given a death sentence, the rate of executions is 8 times higher in the South than in the rest of the country. But let me now go back for a moment to the comparison that I made in the mid-century. Remember when I told you that the ratio was between the South and the Northeast 4-to-1 at mid-century, which was the last time when we were executing almost 100 people a year? Over the period 1980 to 1999, when the South had 81% of the executions in the United States, the Northeast, which is still a pretty populous place, 27% of the American population is in the Northeast. Yeah, but do those states have death penalty statutes? By and large, the answer is yes, they do. Big states. New York had one from 1995 to 2005, no executions. New Jersey had one from 1980 until quite recently. Pennsylvania's had a death penalty all the way through there, and it has more than 300 people on death row. Ohio has a death penalty. And yet the ratio of executions from South to the Northeast during the modern era of capital punishment is now 160-to-1. don't aggregate those patterns to talk about what's going on in the United States. There are very, very different patterns. Okay, this is a 5-year-old pattern, but it divides the country into 3 groupings. Instead of talking about states with capital punishment and states without capital punishment, it divides the United States in 3 different groups. A quarter of the American states don't have a death penalty. That's actually up now, because both New Jersey and New York have joined that quarter. But at that point, the ratio of states with death penalties on the books to other states in the United States is 3-to-1. When you then say, let's forget about laws on the books, has anybody been executed in the last 30 years? The answer is that's a slightly different distribution. 62% of American states have had 1 or more executions. 39% of American states haven't. And if you're a political scientist or a student of this, there may be as much difference between Texas and New Hampshire, which does have a death penalty and last executed somebody in 1937, as there is between formal abolition and having a death penalty on the books. But now we come to the 3rd bar chart there. When you ask how many states execute with any kind of regularity in the United States, the answer is rather extraordinary. If you define regularity as more than 15 executions in a quarter of a century, that is to say, as 0.6 of 1 execution per year, what you find out is 76% of all the American states fall below that standard, and that you're really only talking about a quarter of American states where a year and a half will go by and you can expect at least 1 execution. That should be mildly amazing to folks who live in Huntsville, where when a month and a half goes by, it's probably worthy of some kind of media attention. Okay, let me give you some comparative statistics which are in the book on capital punishment that Ray was kind enough to mention. To explore the legal and operational differences that are behind this kind of extraordinary difference in policy, I compared the 2 largest states in the United States, Texas and California. You know, I'm sitting there in the People's Republic of Berkeley. I know all the California data very well. I'm located 16 miles from the execution epicenter of California, which is the San Quentin Penitentiary, which is in Marin County. If the real estate in Huntsville were priced the way the real estate is in Marin County, you folks couldn't afford to be here, and I couldn't afford to visit. Okay, it turns out that Texas and California had almost identical death row populations on January 1st, 1995. The Texas death row population at the beginning of 1995 was 391. The California death row population was 386. Because of this convoluted series of American Supreme Court cases, most of the law which regulates what death penalties can be provided for and what standards are used to judge executions, that's federal law. So what you have is almost a controlled experiment. You've got nearly identical death row populations. You have the same legal system regulating them. What difference is there going to be in execution results? Remember, death row populations are similar. In the 6 years after January 1st, 1995, Texas conducted 154 executions. California, with an identical death row population, conducted 6. The ratio was 25-1. Execution on California's death row is the third leading cause of death. Natural causes is first, suicide is second, and execution is third. So there isn't any legal difference. Well, then what is the difference? The two overwhelming differences are, one, the quality of defense lawyers and lawyering, and two, less ambivalent attitudes in the state and federal judicial systems, which are linked to Texas. And we have a wonderful example of that, almost from the extremely recent media file. In a case widely reported and decided by the Supreme Court of the United States in 2008, Bays versus Kentucky, a very, very divided Supreme Court, not in terms of votes, but in terms of what the legal standard is, upheld the Kentucky system of conducting lethal injections, but left a wide variety of potential challenges to the ways in which lethal injections were conducted, so that there was tremendous uncertainty about how other states might be judged. What happened under those circumstances? In Texas, the delay between the decision in Bays and the first lethal injection was weeks. In California, it will be 2 or 3 years before we have an outcome. But now, wait a minute. That's federal constitutional law, which is the same in every state. Yup. And if you believe that, I'd like to talk to you about some stock futures. Okay. Now I want to switch to some recent legal and cultural history. In the middle of this incredible mess, and let's go back. That's what's happening to death sentences over this period. What's that about? What's going on? Well, one of the things that's going on took place in the state of Illinois. In Illinois, which is a relatively large Midwestern American state, prior to 1990, there had been no executions. In the 1990s, Illinois became the northern state with the highest number of executions. There were 12 executions, but that was out of a death row that was more than 160. But that 12 executions was the most in the North in the 1990s. But something else happened, and that is during the same period of time, in 13 cases, demonstrably innocent people were discovered on the Illinois death row. 12 executions, about 180 people in death row, 13 of them were innocent. The then governor of Illinois, who has subsequently become himself a participant in the American correctional system, did what any governor does when something highly embarrassing happens in your state. You appoint a blue ribbon commission to study the problem. And that is what happened in Illinois. And that commission, what he said is, how do we get into this kind of trouble and how are we going to get out of it? 215 pages later, they have 85 very expensive recommendations, and they say, by the way, Governor Ryan, even if you do everything we told you, we cannot guarantee you that the risk of executing an innocent person is going to go away. Oh boy. Well, what then did the governor do? And this is going to be the center of what I'm going to be talking about in today's lecture. What the governor did then is a wonderful leading indicator of what's happening to death sentences in the United States, and is going to tell you what's going to happen to the death penalty in the United States in the not so distant future. The governor of Illinois commuted every death sentence in the state. Now that must have been a terribly controversial decision he made. The legislature must have fought it. Nope. Illinois still has a death penalty on the books, but it will be 10 or 15 or 20 years before anybody other than a committed volunteer is at any risk of being executed in the state of Illinois. Okay, that's interesting. It was mildly controversial nationally. It wasn't terribly controversial in Illinois. After it happened, in a gubernatorial election held in Illinois, there was a Republican and a Democratic contestants. They called each other dirty names. This is American politics as usual. But what to do with the death penalty there didn't become a contested political issue. And that's interesting too. If that had happened in 1994, it wouldn't have happened that way. But let me switch to a different state. I'm going from the Midwest now to the Northeast. Massachusetts has gone 45 years without an execution. And it's a big state. It had capital punishment on the books before Furman versus Georgia. It replaced, after Furman, the death penalty statute that it had with a new death penalty statute. But in 1984, the state's Supreme Judicial Court struck down that statute, and the legislature didn't pass another one. But in the late 1990s, the Massachusetts legislature came within one vote of passing a new death penalty law. The then governor of Massachusetts was a young Republican by the name of Mitt Romney, who you may have heard of recently during a more conservative phase of his brief political career. And Governor Romney was deeply invested in finding the perfect death penalty statute, because he wasn't terribly interested in making Boston into the Huntsville of the Northeast. But what he did want was to win a point on principle, to create a death penalty that could support and gain the support of moderate, middle-of-the-road citizens as an issue of principle. So what he did, remember Governor Ryan in Illinois, was he appointed a blue ribbon commission, only he had his chaired by a law professor, to say, okay, what I want you guys to come up with is a fair and relatively low-risk death penalty. I'm very happy to announce I wasn't on that Blue Ribbon Commission. I did get to give a speech at the University of Indiana where the chairman of the Blue Ribbon Commission plies his trade as a law professor. That Blue Ribbon Commission took no position, pro or con, on whether states should have capital punishment statutes. But that Massachusetts Blue Ribbon Commission is an astonishing document. And if you have academic interest in this topic, you should read it, and read it closely. Because what they did do is generated guidelines on what standards they thought it might take to have a capital punishment statute, and to say that their standards were higher than any that had ever been passed by any jurisdiction anywhere is to understate matters. The guidelines restricted potential capital cases on two dimensions: culpability and certainty. On culpability, the commission would require the penalty be considered for only the worst of the worst murder crimes. That's their phrase, not mine. The worst of the worst. And by what criteria you would select the worst of the worst was not clear. But what was clear is that garden variety felony killings, that is to say murder during robberies, which happens 1,500 times a year in the United States and is 60% of American executions, would not be eligible. Rape killings as a class would not be eligible. Killings of law enforcement officers were not an aggravating circumstance in that. By the time it got to the Massachusetts legislature, my guess is there would be some changes in broadening. But again, their notion is, what would a fair and certain and risk-free death penalty look like? So only the very worst of murderers would qualify. Well, now, that was only criterion 1. Criterion 2 was, of the worst, the only circumstances in which a death sentence could be issued was when there was a nearly absolute scientific certainty of the guilt of the defendant. DNA or its scientific or physical equivalent. Well, that's interesting. And again, it's interesting from a diagnostic perspective, but how many cases did this Blue Ribbon Commission think that those two very restrictive standards operating consecutively would leave for the state of Massachusetts? Well, actually, they didn't do any studies of that. They said, no, but if you want something which is low risk and relatively certain, that's how to do it. only a tiny few of the worst and worst are death penalty eligible, and most of those would be ruled out because the ordinary risky standards, confessions, eyewitness identification. So it is not clear to me that there was any case in recent Massachusetts history that would meet the standards of this elaborately constructed proposal. Well, but wasn't that the good news for Governor Romney? Because what he wanted was something that was so safe that in principle, who could object to it? Well, you see, in a funny sense, what the Blue Ribbon Commission did was decide that it was, that Law Day speech we give all the time, it's better that 10 guilty men go free than that one innocent man be wrongfully convicted. But if we repeat that loud enough, we start to believe that it's really an American cultural value. Well, the Blue Ribbon Commission in Massachusetts went further than that. What they seem to be saying is that it's better that 1,000 real monsters get life imprisonment in Massachusetts than that there was any significant risk of executing an innocent person. Well, what happens in that situation? Obviously, then, the legislature is going to pass the death penalty. Let's get back to that in a minute. I think that both Illinois and Massachusetts tell us pretty clearly where we are in the United States and where we're going. I want to start with Governor Ryan of Illinois, now inmate Ryan. Assume that the same guy who came to Governor Ryan and said, look, Governor, we found 13 innocent men on Illinois' death row. Assume that the same guy comes to him now and says, Governor Ryan, we've just done a statistical study, and there are probably 2,000 innocent people in the Illinois prison system. I think, by the way, that's a low estimate, 2,000. I think there are probably 3,000 or 4,000. But they say 2,000. And Governor Ryan's the elected governor of the state of Illinois. Remember, he was the guy that commuted all the death sentences because of those 13 mistakes. Well, he says, I got to be consistent. There are 2,000 innocent people in the Illinois prison system. I've got to close the prisons. Do you believe he'd say that? I don't. He wouldn't have been elected dog catcher with those political instincts. But then why did he so cavalierly close death row in that way? And why didn't anybody object to it? For the same reason that you know what happened to Governor Romney when he took this wonderful Blue Ribbon Commission with its completely sanitized, scientifically how do you think the legislature voted on that proposal? Well, they didn't. They laughed. Why did they laugh? Obviously, if you are going to paint yourself into that strong a corner, what you have essentially said is that this is a penalty that the criminal justice system and that the safety of the streets don't need. Rather than that being a situation in which the political opposition to the death penalty had been neutralized by the specificity and bending over backwards of the statute, what had been neutralized was any political support for a death penalty. And now we want to get back to why Governor Ryan in Illinois wouldn't close the prisons even if there were thousands of innocent people in prison. It's a very simple point, folks. We need prisons. They're a part of the ways in which we respond to and control crime in the United States. No governor in his right mind would take the potential for error in an important part of crime control and use that as a method to disestablish it. But what does that tell us about capital punishment? It tells us that all over the modern world, the abolition of capital punishment has been a two-stage process historically. We'll go back to the long-term stuff. First thing that happens is that executions cease to play any significant part in the control of crime. Then later, whether you're talking about France or England or Russia or the Ukraine, much later sometimes, we stop the practice. And let me give you a news bulletin, and Governor Ryan of Illinois is going to be my evidence there. Executions stopped being anything we needed to control crime in the United States by the middle of the 20th century, if not long before that. And that's not something you can say, oh, well, Zimering told us that we don't need capital punishment to control crime. That's not something Zimering told you. Everybody knows we don't need capital punishment. How many people do you have locked up in the state of Texas? And how many people do you, the execution capital of the Western world, execute? The ratio is 5,000 to 1. Everybody knows we don't need executions. All we're debating in this country is whether we want them. Now, what's the difference between debating whether we need them and debating whether we want them? Well, let's get back to what was bothering Governor Ryan. You remember those 13 innocent men? How many innocent men is a big enough risk not to have a death penalty? The suggestion I'm going to make is that that depends on whether you are debating whether you need a death penalty or whether you're only debating whether you want one. As soon as everybody knows that this is not a necessity for crime control, what happens is the standards where we start really worrying become a great deal more liberal. 1 or 2 or 3 innocent persons being executed is far too many once we acknowledge that we don't really need the penalty. What happened to Governor Romney's death penalty was that it had gotten so tiny and so hypothetical that it was a laughable example of the fact that they didn't need any death penalty of any kind in Massachusetts. What distinguishes Governor Ryan closing death row from Governor Ryan finding some other way to respond to the problem of innocence in the Illinois prisons is that we know we need the prisons. Okay, so what that means is that if we don't want to take risks of fatal injuries, and we don't want to take risks of tremendous injustice, and you know, I think that's what's happening to that Dow Jones Industrial Average of declining death sentences in the United States. Under those circumstances, if we don't need a death penalty to protect the public safety, why play with symbols? As soon as it is widely recognized that the only debate we're having is about whether we want this penalty, not about whether we need this penalty, the long-term result, the long-term outcome has been determined. So in a sense, a visit to Huntsville, no matter how frequent the execution phenomenon seems to you, is also a way of visiting a branch of conduct which is relatively soon, in a historical context, to be indeed only of interest in the context of American history. As long as we don't need it, sooner rather than later, we're not going to have it. End of sermon.
And you will entertain questions.
Questions? Editorial replies?
Can you speak to the recent movement, although somewhat flawed, to try to add non-homicide, non-murder, non-fatal actions as a potential target for death penalty? And what you think the long-term hope is for some people in Africa?
Well, first of all, you give a little bit of a legal history lecture there. If you are talking about American history, capital punishment was, first of all, available for a large series of serious crimes for lots of centuries. As recently as the middle of the 20th century, in highly execution-prone states, and particularly those that were in the American South, in addition to murder, rape was a situation where death penalties were generated in a large number but tiny proportion and selective proportion of cases. It turned out, and there was a criminological study to great effect done of this by Marvin Wolfgang of the University of Pennsylvania, that the odds of a capital sentence, if it was a black defendant convicted of raping a white victim, were rather more substantial than of a white offender raping anybody. Okay. In the case of Coker versus Georgia, the Supreme Court of the United States in the early 1980s held that as a matter of penal proportionality, that is to say, making the punishment fit the crime, this extraordinary punishment could not be justified in a situation where the charge was rape. But the court said, this was the rape of an adult. We will not cover issues not presented before us. That, to a legislature, is an invitation to pass a new statute. And the statutes that purport to punish with death, non-homicidal circumstances fall into two basic categories. One of them is treason and espionage. The Rosenberg executions is the most prominent recent American historical example of that. The other, which was the case that came before the United States Supreme Court last term, was rape of a child. The only issue, and like all of the Supreme Court law on capital punishment, even if it's decided your way, the substantive standards are awful. They go about jurisdiction counting and do a kind of thing. It looks less like moral discourse than like a game of Scrabble or Monopoly. But the important thing in the Supreme Court of the United States these days is counting votes. So the answer to your question, Dennis, is 5-4. And that also tells you, I don't know how many times you're voting next month, but or how many different counties, but this Supreme Court is 2 standard deviations to the right of the United States as a country. Let's go back again to, no, we're not going back. Oh, yes, we are. Here we go. That's what's happening to sentiments in the country. What happened to the Supreme Court was Justices Roberts, now the Chief Justice, and Alito. One more judge, and the answer to the question is non-homicidal crimes will be permitted. Now, if you're asking me for the reasoning, I have no idea. Write a note to Antonin Scalia, my old colleague at the University of Chicago, and I'm sure he'll be sure to tell you. If you're asking me how long something like that would last and who would do it, I'm pretty sure the Texas legislature would pass a child rape law. They're terrible laws for 2 reasons. I'm going to give a little seminar on deterrence. If you're really interested in child rape victims, and if you deeply believe in deterrence, the last thing in the world you want is a situation where you can get the death penalty for kidnapping a child, sexually abusing the child, and letting the child live. And the reason for that is because a very frequent outcome of those kinds of capture scenarios is, of course, the killing of the potential witness against you. So it is a wonderful test in a way. You would only pass a law like that if not only is crime control not your principal goal in doing it, but if you really do not give a flying fandango for the utilitarian outcomes of it, which means that there would be states that would pass it. How often would it happen? Not very often. Why? Because prosecutors are not normally as idiotic as even legislators. There are exceptions, of course, to that rule. That is so far off the charts. There are also places where an awful lot of non-homicidal crimes do result in capital punishment. We've just finished a huge book on Asia. But the only Asian country where child rape became a big issue was the Philippines. And it became such a joke. Non-homicidal rapes were a mandatory death penalty if there was a family relationship in the briefly resuscitated death penalty that the Philippine legislature had created. And that was one of the reasons why they re-abolished the penalty after only 7 executions, and I think rather permanently. Most of the non-homicidal crimes which are punished anywhere else on earth are situations where the utilitarian calculus looks better. That is to say, drug commerce. I think that's probably a lousy idea for a death penalty, in part because if you think you ever get Mr. Big under those circumstances, then I would like to sell you a part of the Brooklyn Bridge. But it at least is not a situation, unlike the child rape situation, where as soon as you know that somebody supports the penalty, it is a fair inference that they're either uninformed about the utilitarian calculus of child protection in those situations, or they don't care. So in that sense, I think that the issue has a deeply interesting clinical significance for talking about American legislation. But I don't think it's the heart of the action. I also don't think deterrence is the heart of the action. I think that when you go back to, what happened to these arrows? When you go back to something like this, you know, that's not a set of criminological findings on deterrence that are going on here. What's happening is that the notion of state killing is being redefined. And I'll tell you what the redefinition is, although I'm going to suggest that you people are no longer as relevant to capital punishment as you would have been 100 years ago, because it is no longer in these 100 countries a criminal justice issue at all. It has become an issue of state power and limitations of state power as a human rights issue. So in a sense, all us criminologists have been shipped off to a sort of a peninsula of irrelevance under these circumstances. This is now a defining issue of politics in the modern world and human rights. And I think that's entirely proper. But I think in a funny way, the historic cause of this is something that it's a sort of a delayed reaction. And it's a delayed reaction to World War II and the political circumstances that created World War II. I told you that long-term trends in executions had been downward in the world. There was one period of time where that was absolutely not true, and that was from 1925 to 1945. Our friends, the Nazis, and our allies in World War II, the Russians, made state execution into an art form. Millions of people were killed. And after that, as a byproduct of the revolution in the PRC and of the right-wing hegemony in Taiwan during the White Terror period and its aftermath, again, hundreds of thousands of persons were executed. It's no accident that the core here, before 1980, of the countries that abolished capital punishment were in short order. First of all the countries that lost World War II abolished the death penalty. Italy re-abolished it right after they hanged Mussolini. Germany in its constitution of 1949, Austria when the left came into power in 1950. And then after the losers had done that, really right after the Second World War, the winners joined that club. England in 1964, France was the last in 1981. So it has been redefined as a political issue, and it is not a question of criminological insight. But That's only true of the death penalty we have left. That is to say, the one that has had between 40 and 98 executions in the last 15 or 20 years in the United States. The one which is a sideshow to crime control and completely unrelated to the major mechanisms of social control of criminal behavior in the United States. So the political redefinition of the issue of capital punishment is something that happened after it ceased to be of any real relevance to crime control. You're going to have to yell at me because I have a hearing capacity which is unfortunately suitable to my age.
Statistically, the annual report from the Federal Department of Criminal Justice seemed to indicate an interesting trend with capital offenders, even in Texas. We recently passed, during our last legislative session, the option for the judicial component to choose execution or true life imprisonment. And I don't know the exact numbers, but in the statistical report that they sent in last fiscal year, there were in the upper 30s, I believe, 38 or so offenders convicted of capital punishment. And a little over 2/3 of those were sentenced to true life in prison as opposed to execution.
Yeah, this is a question of essentially going out of style. Now, some of the mechanisms that we've been using to ease that along create some difficult choices, and I think what you're calling true life is what we call in California, because we tend to use ugly words. We call it LWOP, which sounds like a dirty dance that your children might do just to make you upset, which is life without possibility of parole. In fact, that calls to forth the other thing which absolutely amazes me about capital punishment. And that is that when we look at the regional distribution of where death sentences and executions happen, this produces an absolutely amazing relationship between the propensity of citizens to trust their government and their support for capital punishment outcomes. What's amazing about it is you're talking about the absolutely ultimate state power. And yet, the statistical correlation between levels of trust in government and support for capital punishment is that the more you distrust government, the more you're supportive of capital punishment. Wait a minute, what's going on there? And one of the suggestions that I made in the Contradictions of American Capital Punishment, and we are talking about a contradiction here, is how the heck, and what does distrust of government have to do with LWOP? Why do you pass something which is life without possibility of parole? Is it because you think offenders are dangerous, or you think parole boards are dangerous? I think it's a little bit of both with an emphasis on the latter. Well, one of the chief contradictions is, how can it be that enthusiasm for this ultimate state power is actually associated with distrust of government? Because it's a distrust of governmental leniency is a partial answer. But I think the other part of the answer is that we have seen a real transformation of the story we tell each other about capital punishment to support it. This is no longer about state purposes. It's not a discussion of deterrence or what we need for crime. It is a discussion of crime victims and community needs. We have reimagined a state process as if it's a community process. And the reason we've done that is because people trust their communities. And that the real irony of capital punishment as a state activity is that at least for a quarter of a century, that is not the way in which we have been telling ourselves the narrative of why we need it and who really has the power. It makes it very interesting to study. That's all I can say. We have time for one more? Yes.
So given the examples of other countries that you shared with us, as well as the trend on a state-by-state level within our own country, is your prediction that this will ultimately go by the wayside at the federal level, or each state will just methodically?
Well, yeah, first of all, what do you mean federal level, lady? Let me give you some statistics on federal level. And I think that one of the reasons that capital punishment has persisted in the United States is the federal system. There have been, about 1,100 executions in the United States since 1977. Time sure flies when you're having fun. How many of those executions have been federal? I think it's 3, all during the Bush administration. One of the reasons for that is that 93% of all criminal justice business, that's 93% of all the people in prison, are in state prisons, so that we have a federal system that devolves power in that way. The other reason is we didn't even have a federal death penalty until 1994. And so this one we can blame on the Clinton administration. So the national government has not been an enthusiastic executor at all, and never will be. All of the action takes place at the state governmental level. But the problem is, for anything to happen in less than a millennium, it have to be federal institutions that will move it along. Let me give you a historical hypothetical. If the 2004 election, presidential election, had come out differently, my estimate of the constitutional life expectancy of capital punishment would have been 10 or 12 years. A huge drop. For instance, things like the lethal injection case would have come out in the opposite direction. So we would have been talking about 10 to 12 years. We're now talking about 25 or 30. But again, if you're interested in the institutional apparatus, what happens is that the political system and the geography that I've been talking about will create larger concentrations. The South will go from 80 to 85%. It can't go much further than that. Will create reductions in absolute numbers, and will create a little bit more moral discourse. Under those circumstances, any Supreme Court which is close to the legal mainstream, look, the American Bar Association, these people are not socialists, folks, came out for a moratorium on the death penalty in 1997. The American Law Institute, which blundered into writing everybody's death penalty law but Texas's, in a series of colossal accidents, is about to try and fix that. Under those circumstances, what the Supreme Court will do is to take the substantive question and simply procedurally make it harder and harder. And I'll tell you the way to do that. You remember that comparison between California and Texas? And I said one difference was good defense lawyers. Do you know what difference good defense lawyers make? Oh boy, all you got to do is require them. Okay, but we have a very funny sort of an incentive system. The state are the people, those are the folks that want to have the death penalty. They're also the people who have to pay the lawyers, who defend people, and who create the minimum standards of what effective defense work looks like. Is that a conflict of interest? I think it was the Ohio legislator, who was also an oil man, who said, conflict of interest? My interests aren't in conflict. Okay, so you'd get a real procedural tightening. And then what you would get is a de facto moratorium. And then you would get a constitutional closure. I will have to live extremely healthily to see that happen. But that's only because of the 2004 election and the 2 judges who are already in. And my 25 years becomes a 32-year projection if the election goes red in this country. But under those circumstances, my friends who are survey researchers will no longer be making fun of criminological scientific standards. It depends, because of the American federal system, very much on presidential leadership in this country. In the ordinary course of events, the political situation in the United States on capital punishment is not that different from the political situation in lots of countries that abolished. The number of people who support the penalty is no higher here than it was in England, France, Canada, Germany, all over. The difference is the people who care about it in support care about it much more here than in any other country in the world. In the People's Republic of China, which executes 98% of all the people executed anywhere on earth, the average citizen supports capital punishment and doesn't give a rat's ass about it. If you wanted to change it, it wouldn't be a 0.5 on the Richter scale. You want to change it in Texas, and you'll get to know the Richter scale ultimately, because what you have here is a much stronger emotional tie, not a larger percentage of the population. And what that's about is a matter of great cultural and historical interest. I got a theory. I've got a dog in this fight now, but it's not necessarily one which is universally popular.
Let me remind you, the doctoral students are invited to the flag room immediately after this. Lunch at 12, back to the doctoral students at 2 o'clock. Form on the flag room. Thank you very much.
My pleasure.